Η πρώτη ομιλία μας θα είναι από τον πρόεδρο του Ομοσπονδιακού Εφετείου των Ηνωμένων Πολιτειών, που έχουμε την τιμή να έχουμε μαζί μας σήμερα, τον δικαστή Μάικλ Τσαγκάρης, ο οποίος έχει μια εκτεταμένη δικαστική εμπειρία στα ομοσπονδιακά δικαστήρια ήδη από το 2006 και έχει ταυτόχρονα και δικηγορική εμπειρία παλαιότερα. Η παρουσία του εδώ σήμερα τιμά όλους, τιμά την συνδιάσκεψή μας και θα μας προσφέρει τις πολύτιμες σκέψεις του σχετικά με τα μείζωνα ζητήματα που μας απασχολούν. So we have the honor to have with us Chief Justice of the U.S. Court of Appeals, the Third Circuit, the Honorable Michael Chagares. Justice Chagares has served at the federal courts since 2006. He has an extensive judicial experience, and through his previous appointments and has fought for the rule of law and has also participated in executive panels, on the judiciary, mostly focusing on the administration of justice. He has also extensively written with regard to procedural law, and therefore his insights on all the issues that are of concern to us today will be valuable, very valuable. Thank you. The floor is yours. Thank you so much.
Thank you for that very kind introduction. I'm really greatly honored to be a part of this milestone summit, and I'm grateful to be asked to deliver a keynote address today. I think this summit is a celebration of the incredible influence that our Greek brothers and sisters have had not only on our systems of justice, to which we all contribute on a daily basis, but also our modern civilizations more generally. My family started here in Ios Petros. We became a part of the Greek diaspora. My parents and grandparents sold bananas in New York City, in that area, and that set a foundation for me and our family in the United States. You may have a similar story. In the United States, Greeks are well represented in the law and have strengthened our system of justice. We have many notable judges and attorneys here with us today, and other judges, Greek judges, include my colleagues, Stefanos Bibas, Gregory Katsis, and Nick Garfoulis, and many, many others. There are and also have been many Greek elected lawmakers in the United States House of Representatives. I think there are 6 right now, and the United States Senate, as well as many elected lawmakers in state governments. Today, I'm going to speak about several topics, largely guided by the title of our summit. So my topics will include democracy, the rule of law, judicial independence, threats to all of them, as well as the emerging subject of artificial intelligence, or AI. I'd like to start with the fundamental concept of democracy. It's perhaps our people's greatest gift to humanity, and it all started right here so many years ago. What a remarkable and crucial innovation. Democracy is best known really for affording political power to people elected in free, consistent, and regularly scheduled elections. I'll speak more about the rule of law in a few moments, but the rule of law ensures that rules are known, followed, and applied impartially by these elected representatives, judges, and by everyone else in society. As they say in the United States and elsewhere, nobody should be above the law. Democracy and the rule of law are necessarily connected. And I don't think that I'm going too far when I say a robust rule of law is a requirement of a strong democracy. For instance, Democratically elected representatives are accountable to the people, and that accountability in a democracy is compelled by the rule of law. So let me pivot just a little bit. And this ought to be interesting in terms of the translation, but here goes. The enigmatic baseball player, Joaquin Andujar, once said that baseball can be summed up in one word, one word. And that one word is, you never know. The guiding principle of our systems of justice similarly can't be summed up in one word, but their cornerstones can be summed up in three: rule of law. Unfortunately, the rule of law is not easily defined. I was giving a lecture at a high school this year about the rule of law, and a somewhat frustrated student raised his hand and asked me to give him an example, help him understand what is the rule of law, what does this important phrase mean in more concrete terms. He's right. I mean, it's not very easy, really. I pointed out that the rule of law touches everything about how our society runs. So I asked the kids in the class to imagine going to buy a cup of coffee. And kids these days like lattes and other types of fancy beverages. But still, go buy a cup of coffee. You would expect perhaps to cross the street safely to go to the store. And I pointed out that the rule of law compels drivers to stop at lights or to make sure they don't run over pedestrians. You would produce money or a credit card at the store to buy a cup of coffee, and it'll be accepted because the rule of law assures that monetary systems are stable. You won't be overcharged because consumer laws and even criminal laws protect consumers. That's a part of the rule of law. And you can drink the coffee and won't worry too much about being poisoned because there are food and sanitary regulations that stores must follow. Again, part of the rule of law. The kids then were prompted to say, well, then the rule of law sounds like it's important and fundamental. And they were right. Notwithstanding the difficulty in defining the rule of law and its complexity, there are several pillars of this important concept. First, laws need to be publicly known, what it is, what is expected of you. Laws must be equally enforced, the rich, the poor, to everyone. No one is above the law, as I said. It protects against the tyranny of the majority. Again, it protects minority rights, unpopular views, for instance, speech, religion, even searches and seizures. The law is independently and fairly adjudicated according to application of law and not in the unlimited exercise of discretion. And if those considerations don't move you, there are other reasons why the rule of law is so crucial to people in a democratic society. It promotes prosperity. It promotes economic stability. It leads to consistency, predictability, and people understanding what they can and can't do. So it links people in a democracy together, creating a certain trust and harmony. And it's a promise that you'll have freedom and a promise of self-dignity. One way the rule of law is enforced is through oaths. Oaths are sacred promises that we make, and we've all taken them. I took them when I was being admitted to practice law, when I became a prosecutor, and when I became a judge, and probably other times as well. We may not have paid great attention to oaths, but they're important, and they're worthy of consideration. In ancient Greece, oaths were sworn to the gods. A broken oath might lead to punishment, including a year-long daze, extinction of a family line, or even death. Perhaps you remember in the Odyssey when Odysseus's hungry men broke their oath not to kill and eat any of Helios's cattle. Well, that didn't go so well. Zeus exacted punishment, sunk their ship, and only Odysseus was saved. Incidentally, I learned on the flight over here that apparently, look, next summer, the Odyssey is going to have a big Hollywood splashy movie. So something for next summer to look forward to. Anyway, jurors in ancient Athenian courts actually took an oath. It was the Heliastic oath, and that oath included a solemn promise to cast one's vote according to the laws and decrees that existed. If the oath was disobeyed, a juror could face divine punishment from the gods or face a curse. Pretty serious stuff. Oaths reinforce the rule of law. In the United States, as I understand it, the first judicial oath read simply, quote, "I do solemnly swear that I will support the rule of law of the United States." Later, oaths became more specific, committing judges to taking an oath to uphold the Constitution and laws of the United States. Attorneys, jurors, and even military members take similar oaths. U.S. military oaths, and as I understand it in all countries, reinforce loyalty to the rule of law, not to individual leaders or to certain policies. In contrast, while in pre-Hitler Germany, German oaths were sworn to the Constitution and law, Hitler changed the German oaths to swear loyalty to him. Pretty interesting. The oaths you took bound you to be a guardian, a steward of the rule of law. These oaths preserve democratic principles. May we all remain loyal to our oaths and to the rule of law. Now, I'd like to move on to the importance of an independent judiciary in a democracy. The judiciary plays a crucial role in protecting the rule of law. It also ensures that judges have the freedom to make independent decisions. And it also makes sure that decision-making is insulated from external pressures, other citizens, politicians. It was Aristotle who championed the idea of a mixed or blended state of split power. He thought that that was the best way to avoid a tyranny. The United States conception of judicial independence has some English roots, as our friend from Australia told us. Judges in the early modern period could be removed by the English monarch, especially at the Crown's will. Sir Edward Coke, for instance, was removed from the bench by King James I by suggesting that the judiciary had the authority to review acts of Parliament. Parliament eventually passed the, quote, Act of Settlement, end quote, which provided judges with tenure, a fixed salary, and a guarantee that they would not be removed unless both houses of Parliament directed it. In fact, King George III publicly lauded independence, judicial independence in 1761 as, quote, essential to the impartial administration of justice, as one of the best securities to the rights and liberties of his loving subjects, as most conducive to the honor of the crown. Well, that does sound good, but this English concept of judicial independence did not extend to the judiciary in the American colonies, and that was a problem. Judges in the colonies faced restrictions and threats to tenure and salary at King George III's whim. This lack of independence was one of the motivating factors driving the United States Declaration of Independence, and later the Constitution. The Declaration of Independence made this clear, complaining that the king made judges, quote, dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. So the United States Constitution, not surprisingly, affords federal judges lifetime tenure as long as they do not fail to exhibit good behavior, felonies, etc. I don't plan on displaying any bad behavior, so I hope I make it to pension. But in any event, it's a guarantee that judges' compensation will not be diminished during their service. One of our founding fathers, Alexander Hamilton, remarked that preserving judicial independence provides, quote, a barrier to the encroachments and oppressions of the representative body and is, quote, the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. As a federal judge, this gives me assurance that I can decide cases fairly and according to the law without fear of losing my job or salary. And there unfortunately are, though, recent instances where judicial independence, not unfortunately, sorry, there are notable instances where and I think the United States public and perhaps the world saw that there was independence, judicial independence and respect for the rule of law, and it was demonstrated. And the one case that comes to mind is Bush versus Gore, and this dealt with the presidential election of 2000 rather. You may remember that one for those of you old enough. I sure am. It dealt with hanging chads, and there was a problem with ballots, and there was a real concern about who actually won the presidential election in 2000. Well, the United States Supreme Court, it got to that level, and the United States Supreme Court decided essentially in favor of who became President Bush. The losing candidate, Al Gore, noted, quote, "Now the U.S. Supreme Court has spoken. While I strongly disagree with the court's decision, I accept it. I accept the finality of this outcome." Notably, there was no revolt, there was no violence. The Supreme Court decided it. It was just the acceptance of the working of an independent judiciary and the application of the rule of law. An independent judiciary is critical to protecting the rule of law. I'd like to turn now to some threats, some potential threats to democracy, the rule of law, and judicial independence, and what can be done to avoid these threats. A topic of this summit is artificial intelligence, AI, and there'll be some exploration during the summit, and already really has, about AI's effect on the law. Frankly, AI can be a bit intimidating, particularly for someone like me who's not terribly tech savvy. I'm not an expert in AI at all, and like many of you, I'm trying to wrap my mind around what actually it's all about and to try to understand it a little more fully. A valid question is, does AI pose threats to our system of justice? To be sure, AI offers many benefits, and it's also constantly evolving. It can promote efficiency and speed. As you know, attorneys are using it in many different ways, including drafting letters and other documents like briefs, reviewing records, synthesizing facts. Pro se litigants, unrepresented people, use it or can use it to perhaps better press their arguments. That would be an improvement over some of the pro se submissions that we receive, unfortunately, sometimes scrawled on napkins and written in crayon. Unfortunately, justice may be better served by if they're able to make their valid arguments in a more coherent way. There are some practical concerns, though. Judges are receiving briefs with hallucinated or fake case citations and other citations to authority. Judges and the judiciary are trying to grapple with that now. Please be careful. U.S. judges are really hyper aware of this and are sanctioning attorneys who misstep. We've seen examples of where I had one the other day where a lawyer gave us cases that just never existed. The excuse, not sure it was a good one, but the excuse was, oh, my client gave these to me. And I only now found out they were AI. I'm like, well, I think you have a responsibility there somewhere, but okay. Anyway, please check the authorities that you cite when you write things to the court before you include them. Another practical concern is privacy. You don't want to compromise client data. Similarly, courts don't want to expose their thinking about cases before their final written opinion is issued. I actually asked my law clerks not to use AI if possible, and let's keep everything in chambers. In talking about it recently, actually in preparation for this address, we all realized that perhaps we're using AI and we don't even know it. So that may be you as well. Another concern is how this all will affect the need for new attorneys. I know we have some new attorneys here. I teach a course at law school in the United States. I can tell you that students are a little bit worried about their career choice right now, at least in the United States, particularly after investing so much money, time, and effort in law school. Some have argued that AI might result in a decreased need for new associates. I'm not so sure. I'm old enough to remember when Lexis and Westlaw came out, and the same thing was said. We won't need you. And I think that the hiring of lawyers went up after that. So I'm hoping young lawyers, I think you're good. Uh, a concern about AI is how it's becoming increasingly important in human decision making. And that means AI is gaining more control and responsibility. I don't mean to sound paranoid, but some have even suggested that AI could take over the judging function. And it's even being used in some private adjudications right now. Uh, Arguments in favor of using AI in adjudications include efficiency and speed, statistically sound results, and absolute adherence to the law. I think of complex regulatory matters like taxes. Maybe it would be appropriate for that kind of a thing. I'm not advocating for it, but I'm just saying. There's some interesting scholarship out there about future uses of AI and its impact on the rule of law and on judicial independence. Regarding the rule of law, some scholars have concerns that AI will make the law not as accessible to all segments of the population, to the public. They call that the digital divide. There's also a concern that the decision-making process of AI was too complex for the public to understand, or to simply, it's just simply too hidden. Uh, Experts call that the black box problem. In contrast, when a human judge like myself renders an opinion, my thinking is in a written opinion. And, whereas my grammar may not be the best, you can tell what I'm trying to say mostly, I think. So as one alarmed scholar questioned, with AI, do we have the rule of law or the rule of algorithm? So something to think about. Others note that AI's output is only as good as the data sets it relies upon, and almost all data sets are affected by some bias. But compare this to the complaint that judges may also suffer from implicit biases themselves. Plus, the fairness that's a pillar of the rule of law seems implicated, as AI cannot exercise compassion and equity like humans can. And balancing various factors does seem to require some human discretion. And what about judicial independence in AI? Some other scholars have questioned whether decisions are really independent if judges rely upon outside systems or companies. And what about the dignity and respect for what has always been a human-led process? And our venerable jury system, will that be affected by AI at some point? Juries are sometimes regarded as unpredictable or slow. And for those like myself who have tried cases, we know juries are susceptible to emotion, and not so much with AI. So while AI offers some very extraordinary benefits, ones that we'll only realize in the upcoming years, there may be drawbacks as well. And they could affect the rule of law and judicial independence. As I said earlier, AI is evolving rather quickly, and so are its uses. So courts, including my court, we've considered regulating it. And I've set up two committees in my court. I'm in a regional court, so I have different states that are part of my jurisdiction and sort of the bigger jurisdictional area. We're trying to wrap our minds around what AI is and what it's doing, and how lawyers might be using it, and how we might be able to regulate it. Well, at this point, we've decided against regulation and just leaving the regular rules, including candor to the courts, to police this. But I don't know in the future what we might end up doing court-wise. I I know there are some courts in the United States that will require some sort of a certification by a lawyer that AI was either used or not, and if it was used, that the lawyer is certifying or swearing that they checked all of the citations. So that's one possibility, I suppose. My suggestion to you is just use care. Check your work, be mindful about how much control you are ceding to AI. Moving on from AI, I'm afraid that, and as you probably realize, democracy and the rule of law are inherently vulnerable. Ultimately, the rule of law depends upon the citizen, who we elect, and the soundness of the laws that are enacted. But questions abound. Will laws be applied consistently? Will elected officials follow the law or act arbitrarily? Will they abide by decisions of the courts? Will rules be publicized for all to see and understand? These are all legitimate, elemental concerns. And will elected officials and the public respect judicial independence? In the United States, many citizens believe that judges are simply politicians wearing black robes. The press refers to judges as Bush judges or Obama judges or Trump judges or Biden judges. It reinforces some of this. The rhetoric against judges is sometimes very intense and very sharp and harsh. It threatens the rule of law and judicial independence and democracy. Criticism is fine and can even be constructive, even against judges. And I don't know a judge who really would disagree with that. But questioning the legitimacy of judges and hyper-partisan attacks are really damaging. I might add that these attacks are not limited to a single political party in the United States or elsewhere, and I understand they are happening in other countries. In the United States, threats against judges have doubled since 2021. It's a real problem. Perhaps people are trying to intimidate judges to steer results to their liking. And I'm afraid I have a few examples of this. You may have read in the paper, one of my colleagues actually, her name is Esther Salas, she is a trial judge in the United States, a disgruntled attorney of all people, showed up at her house on a weekend wearing a FedEx uniform, rang the doorbell and opened fire, killing her only son, injuring her husband mortally. She was in the basement. She was not injured, but her life has changed forever. You'll see her on CNN. She's really taken to telling people about keeping the rhetoric at a moderate level and the threats against judges. It's an interesting thing, something that's happened more recently, which is just a terrible thing. Some people who do not like decisions judges are making are finding out online judges' home addresses and are sending them pizzas. The point is, we know where you live, and that's a real threat. I can tell you my story. I decided a case back when, after the 2020 election, involving the presidential election. I got threats. I had to have U.S. Marshals stay with me and my family for a while until it seemed that things were calmed down. That's not a good place to be. I accept that responsibility as a judge, but when I draw my wife, who's here with me, and my family, I have 4 children, that's a lot. My parents live in town. It's tough. And it's just not something that we should have to deal with in a civilized society. As a matter of fact, I had another threat in a completely unrelated matter. I actually had to testify as a witness against, and it was a few weeks ago in Philadelphia. A guy had 2 death threats against me. He was unrepentant. He looked me straight in the eye and told me he wanted to kill me, which is shocking. The jury found him guilty of both counts. He'll be going to jail for quite a while, but nonetheless, it's a very interesting thing to look at another human being in the eyes, and they're telling you, for reasons you can't really understand, that they want to kill you. I can understand how that might be intimidating. And so these are very tough circumstances that judges face today. It's very difficult. It's contrary to the idea that judges should decide cases without fear or favor. And what about democracy more generally? One of our former Supreme Court justices, Anthony Kennedy, is worried about risks to democracy. And he's retired now, but this is his life's work now. And he worries that when discourse among citizens, at least United States citizens, is hostile and fractious and centered often on identity politics, that rather than speaking civilly and respectfully about the issues, that's a threat to democracy. But I think notwithstanding this parade of horribles that I've laid out, I think there is reason for optimism. And my optimism actually springs from judicial systems. And that's judges and attorneys like you. And think about it. Our justice systems stand tall as a place where heated rhetoric and uninformed opinions are rejected outright. We rely upon evidence and the rule of law. Speaking about the courts, I like to think we're the refuge for the powerless and the powerful alike. And they're also venues where civil, respectful, and courteous discourse occurs. Hearings in court are not interrupted by shouting and outbursts from onlookers or abusive conduct. The courtroom is a place where all are invited and welcome, where the public comes to resolve its conflicts. It's also a place where the public, sitting as a jury, tells us what justice is, where being right is more important than being popular. Without our system of justice, where would people go to vindicate their freedoms? Our justice system is critical to the functioning of our democracies, and a justice system that does not have the public's trust erodes our democracies. Let's face it, there's a lot of noise out there confusing people, whether it's called hyperbole, fake news, or otherwise. Today's society has so many divisions, and technology, while increasing communication, also depersonalizes it. There was a time when interactions consisted of less emails and more handshakes. Unfortunately, this has meant, at least in the United States, that public confidence in our justice system has gone down. Yet the traditions of our justice system, such as the rule of law, make us what our former Chief Justice Rehnquist called the crown jewel of our democracy, and I think he was right. We are all part of our respective system of justice, my Greek brothers and sisters, and we should all feel a deep sense of pride about it. We are stewards of something very special, and we share in the responsibility to support our judicial systems, our justice system. So how exactly can we improve confidence and trust in our beloved justice systems and bolster our democratic ideals as well? I think that education is one important way. We can educate our neighbors, adults and children alike, to become effective citizens and leaders in our democracy, and to understand how the judicial system works, to produce fair, impartial, and apolitical results. Survey results, at least in the United States, are clear that those who know more about the justice system are more confident and trusting of it. But other survey numbers about the lack of knowledge about the justice system would be funny if they weren't sad. For instance, 2/3 of Americans can identify one of the judges on the television show American Idol, but only 15% can identify the Chief Justice. 3/4 of Americans, 75% of Americans, can name the Three Stooges, but 3/4 don't know the difference between a judge and a legislator. And only 1/3, 33% of the people can name the three branches of government in the United States. Now, I'm pleased to say that substantial efforts are in progress in the United States to educate the public about civics, including our judicial system, the judicial independence and the rule of law. Think about getting involved wherever you are in those efforts. Give others the benefit of your knowledge. You can speak to groups of children, even adults. My court has been involved in moot court competitions for young people, naturalization ceremonies where all are invited, essay contests for 5th and 6th graders, elementary school children, on topics such as our most recent one was, what does the rule of law mean? And the winners are hosted at the courthouse where they get prizes and get a tour, and it's really exciting. Lectures to colleges and law school students, tours of courthouses, and we even do a video contest for high school students on the importance of democracy. We even do a few of our judges even teach civics education at community colleges to adults. Again, I encourage you, all of you, to get involved to support your respective judicial system. You'll be heartened by and amazed by the reaction to your efforts. There's a second way that we can educate the public about our systems of justice, and that's by example. All of your clients need to know that they're important and have a chance to be heard. They may not like the end result, but they need to know that they've received a fair shake and they're respected. We have a responsibility to promote these ideals. Perhaps you'll influence others to model your civility and respect and reduce the heat of discourse elsewhere. So conflict can be constructively managed elsewhere. In fact, one of my predecessors, the first African-American judge in the United States, once wrote, "The lawyer's professional knowledge and understanding necessarily enlarge his role and potential influence on society." That is you too. We need to be examples for our society. And as the American performer and social commentator Will Rogers once said, people's minds are changed through observation and not through argument. So what do people see when they observe attorneys? I think they see people involved in what is a helping profession. Helping others is what our profession is about, I think. Now, people see the way judges act in resolving disputes and disagreements, so judges have important responsibilities, including attorneys, parties, and witnesses respectfully and with dignity. So that means judges should not use hostile or demeaning words toward counsel or anybody else in court or in written opinions. Judges should respect the time schedules of all who appear before them. And judges should make timely, fair, and impartial decisions that the public can understand. When multiple judges are sitting together, as they do in my court, we should treat each other respectfully, regardless if we disagree. So for the sake of our system of justice, people must see and understand that we treat each other civilly and courteously, even if people in other arenas treat each other uncivilly. And people must see that conflicts are involved in an environment where polite and rational discourse is expected and is valued. And conflicts are not resolved in reliance upon baseless statements or insults, but on evidence and the rule of law. Preserving and promoting people's faith and trust in our beloved system of justice is a task for all of us, judges, justices, and attorneys alike. So I leave you with a thought. May the people know that we are not attorneys. May the people know that we are attorneys not by our titles and by papers on our walls, but how we treat them and how we treat each other. Now, I just have a few more words. We are part of a noble profession. One that I think, as I mentioned earlier, that can be described as a helping profession. You are stewards of the rule of law, and you often act as the voice for the voiceless. To be sure, you've touched a lot of lives in your career, brothers and sisters. But let's pivot for a moment to those who have touched your life. You didn't get here alone. We proudly stand on the shoulders of our predecessors who all started here in Greece. Some continue to live in this wonderful country. Some live elsewhere. But behind all of you were people who supported you, who cared about you, who worked hard, who instilled certain values. It may be that they believed in you when your belief in yourself was shaken. Maybe it was parents, siblings, friends, priests, professors, significant others. Please remember that today and pay it forward to somebody. As Pericles once said, what you leave behind is not what is engraved on stone monuments, but what is woven into the lives of others. Thank you again for the great honor of permitting me to address you today, and I look forward to the remainder of this summit. Thank you.
Thank you very much, Chief Judge Chagares, for a very compelling and thought-provoking address. Your remarks have given us much to consider about the fundamental pillars of our democratic society. Chief Judge Chagares illuminated the vital connection between the rule of law and democracy, but also economic prosperity and political stability. He tackled crucial questions about artificial intelligence, especially regarding transparency regarding the use of artificial intelligence models, and also was very emotional and touched us all with his remarks about the need to enhance the judicial system, our judicial system, and our confidence, the public's confidence to the judicial system, as well as forging strong bonds between the legal community, which is precisely the spirit of our global summit. Thank you so much again. Θα περάσουμε τώρα στον τελευταίο κεντρικό μας ομιλητή από την Κύπρο, τον κοσμήτορα και καθηγητή του δικαίου, τον κύριο Εμιλιανίδη, ο οποίος με μια μακρά ακαδημαϊκή διαδρομή έχει θητεύσει, θα έλεγα, και στο δίκαιο της κοινοπολιτείας και στο δίκαιο στα υπηρετικά δίκαια, και με τον τρόπο αυτό νομίζω μπορεί να γεφυρώσει τις ένομες τάξεις που είναι σήμερα εδώ παρούσες. Νομίζω ένα από τα μεγάλα πλεονεκτήματα αυτής της συνδιάσκεψης είναι ότι αποτελεί έναν συγκερασμό από τη μια του δικαίου, του κοινοδικαίου, του common law με ένομες τάξεις που εκπροσωπούνται από εκεί, και από την άλλη της υπηρετικής ευρωπαϊκής ένομης τάξης. Η ελληνική είναι μέρος αυτής, πάντοτε με ένα κοινό νήμα που είναι οι κοινές αξίες τις οποίες υπηρετούμε, το κράτος δικαίου, η δημοκρατία, τα ανθρώπινα δικαιώματα, αλλά ταυτόχρονα και η παρουσία Ελλήνων νομικών που υπηρετούν με επάρκεια και τα δύο αυτά νομικά συστήματα. Κύριε Κοσμήτορα, ο λόγος σε εσάς.
Dear colleagues, thank you very much for the invitation to be here today in this important conference. I truly thank the organizers for this kind invitation. Let me add to your comment, Mr. Chair, that Cyprus actually is a mixed legal system. It is actually the only known mixed legal system that is in the reverse, in the sense that the other known mixed legal systems have the public law being common law and the private law being continental law, where Cyprus is the only known example of the reverse, namely public law being continental law and private law being common law. So Cyprus is indeed, anyway, a mixture of both continental and common law. In my speech today, I will start with some brief comments about the legal profession and its role. I believe that when we are discussing the role of the legal profession in facing the challenges regarding rule of law we have to start with the fundamental questions governing the legal profession. I will then proceed with some comments regarding rule of law challenges today, and I will finish my speech focusing in particular to some challenges posed by AI. In general, there are 5 accepted features of a profession. There has to be a governing body that represents the profession, that has powers of control and discipline over its members. Second, there has to be some mastery of a specialized field of knowledge through education, training, practical experience, and continuing study of developments in both theory and practice. Third, the admission to the profession has to be dependent upon a period of theoretical and practical training, in the course of which it is necessary to pass examinations and tests of competence. Fourth, there has to be self-regulation, so that members may be required to observe higher standards that could be successfully imposed from external pressure. And the fifth one is that a professional first and foremost responsibility is towards their client, who deserves high level of care and attention. In this respect, the status of the profession is affected by 2 principal factors: membership and clientele. Lawyers expect high status, rewards, autonomy, and some restraints on competition, while at the same time it is expected that there is an obligation on their part to provide a measure of competence, access to the legal system, a service ethic, and public protection in return. Clearly, one of the most difficult questions in practice is whether the increasingly competitive search for clients might force lawyers into an ever more single-minded pursuit of their clients' interests, regardless of the ethics of the methods required and regardless of the public interest. This is today all over the world and growing discussion, both because there is a significant growth and diversity of the legal profession. How this would affect the lawyer's role in safeguarding the rule of law, human rights, and the justice system as a whole is of paramount importance. In this respect, the self-perception of lawyers as a loose fraternity of peers, indicated also by the presence of so many lawyers from across Hellenism in this room, has been instrumental over the years in safeguarding that they would broadly and in their majority respect the rules of the system. It has been argued that the profession of the lawyer in particular has 4 distinctive features. Namely, that a lawyer is not called upon only to serve their own good, financial or otherwise, or the good of their client, but also have a duty through also their bars, their regulated associations, to serve the good of the community as a whole, and that makes them differ from other professionals. The lawyer is anyway described as an officer of the court, as an officer of justice, and must struggle, therefore, between public interest and the interest of their clients. Secondly, despite its specialization in various subfields, the legal profession remains generalistic in that the primary concern of legal education is to train students to think like a lawyer. Third, the lawyer must have the capacity for judgment. No knowledge is enough if the lawyer cannot think, feel, and understand their adversary's point of view. And of course, as is often said, a lawyer's soul and mind belongs to their work. And the fourth is that the law is internally and not simply externally connected to the past. It is a continuous collaboration between many generations and has a self-conscious historical depth, a colleagueship with the dead and the unborn. The Chief Justice mentioned just before about standing in the shoulders of those who came before us. He very cleverly didn't use the term often used, shoulders of giants, because in the legal profession in particular, we do not rely only on giants. We rely on all justices, lawyers that came before, because you do not need to be a celebrity. You do not need to be someone who is recognized all over. Each one does their own work, which is highly important, and that's why we always cite decisions from previous judges where there was participation from previous lawyers and, of course, also academic texts. Lawyers are expected to perform, therefore, two distinct professional duties. On the one hand, to keep their client informed, safeguard their interests and secrets, provide competent and diligent services at a reasonable fee, and abide by their clients' wishes concerning the purposes of the attorney-client relationship. On the other hand, they are called to function as officers of the court, so that they do not counsel or assist the client to perform fraudulent conduct, file frivolous claims or defenses, unreasonably delay litigation, or intentionally fail to follow the rules of the tribunal, or unnecessarily embarrasses parties. However, obviously, clients are not interested to deter violations of the lawyer's duties as an officer of the court, especially when such violations further their own interest. So lawyers are often faced with a client who expects them to act contrary to their professional obligation. State officials, on the other hand, and of course nowadays journalists and social media may have little interest in ensuring that the lawyer represents clients competently and effectively. Whenever you take on a client, you represent a client that the social media doesn't like, they will try to embarrass you into not handling their representation effectively. Some clients will hire a lawyer only once in their lifetime, whereas for others, like corporations, interacting with lawyers is a way of life. As frequent consumers, corporations have both the incentives and the resources to reduce the information asymmetry that usually exists between clients and lawyers, even hire in-house lawyers to help them identify their legal needs and monitor attorney performance. Corporate clients, therefore, often have a strongest degree of reliance, and the lawyer might become more dependent upon them, either for financial grounds or otherwise. Corporate clients are also rather unlikely or unwilling to use the existing disciplinary system, even when they have actually been harmed by lawyer misconduct, whereas individual clients who are more willing to use the disciplinary system are unlikely to be able to utilize these controls in an effective manner, since they rarely know which services they need or do not have access to information that would allow them to evaluate the quality of the services that a particular lawyer is likely to render. Therefore, they are often not able to evaluate the quality of the services performed. In the literature, there are four prevailing models for the lawyer-client relationship. The first is lawyer as a godfather. I do not mean the movie, who assumes that the client wants victory or maximum financial return, and that the lawyer's role is to pull any of the levels likely to achieve success. Legal techniques are considered to be the only means, while damaged relationships, animosity, and bitterness are not factors to be considered. The second is a lawyer as a hired gun who practices client-centered counseling. The decision under this idea, this model, has to be of the client alone, free from the influence of the lawyer. The lawyer must therefore refrain from non-legal advice until the client has made their own decision, at which point the lawyer may point out their opinion, which shall be withdrawn if the client rejects it. The third model is the lawyer as a guru, who is concerned that the client must do the right thing, regardless of the client's opinion on the matter. And guru overcomes the client's decisions in the interest of third parties or the client's own perceived wider interests, as they are perceived, of course, by the lawyer. The guru is therefore prepared to even manipulate the client or withdraw should the client refuse to follow the lawyer's advice. And the fourth model is the lawyer as a friend, in which case the client is understood as the product of a series of communities and relationships, with the crucial question being whether the relationship between the client and the lawyer has influenced positively other aspects of the client's life. These are, of course, all interesting models, although the standard conception of legal ethics is based on two main principles: the principle of neutrality and the principle of partisanship. The principle of neutrality states that the lawyer may represent people who wish to employ the lawyer's services regardless of the lawyer's opinion on the justice of the cause, whereas the principle of partisanship enables the lawyer to do everything to further their client's interests, provided that they are not technically illegal or a clear breach of a rule of contract. The argument of a deprofessionalization of lawyers is therefore up to an extent unrealistic, since professional roles have important social value, and in the case of lawyers, they are connected with the profession of fundamental constitutional rights. There are two prevailing images of a lawyer. The one that we lawyers often do not like is as a plumber, namely as someone who is a master of a specific specialized knowledge. The other, of course, is the lawyer as Pericles, the lawgiver, the policymaker, the wise judge. Even assuming, however, the image of a lawyer as a plumber, responsible professional judgment must rely heavily on the concept of responsibility. The lawyer is not a mere technician, since their role involves the exercise of good judgment. I would argue that the crude autonomy formula, which suggests that lawyers should simply state the facts and let the client decide, is unworkable, because the client is influenced by the manner that the information is presented to them and is many times unable to decide, either due to their emotions or because they are lacking requisite knowledge. The crude paternalistic view is also unacceptable, since effectively it would lead to the lawyer deciding instead of the client. I would therefore argue in favor of a refined view where the lawyer must educate themselves about their client's concerns and assist them in making use of the necessary information. Clients need to be able to trust the justice system, and that means also their lawyers and judges, and the ability of their lawyers to care for the cases brought before them. We routinely deal with people who are facing personal tragedies, financial collapses, or need advice in order to become more competitive or to simply safeguard their current status. A person should have the right to expect from all actors of the justice system to be knowledgeable in the law, to have common sense, and to care about the specific case that they have to deal with at any given point in time. Continued delays and lack of adaptability are obviously two main concerns, two main problems that our legal systems are facing that are jeopardizing rule of law. But there are more. Lawyers, as described above, have themselves an obligation to fight for the rule of law. As famously said, the objective of the law is peace, and the only way to succeed, to achieve this, is through struggle. And we did live in an era where struggle is necessary. There is a global erosion of public trust to the justice system and towards legal institutions. This is fueled by polarized politics. It is fueled by the use of social media. It is fueled by many factors. But this has undermined significantly confidence in the authority of justice. The thing is that obviously justice system has its flaws. Any human invention has their flaws. But when public confidence in it erodes, then a very substantial part of what can make the justice system work does not function. The US was mentioned before, and the US is very important because in the post-Second World War era, the US has been the leader of the Western world, and the Western world is the leader in promoting the notion of what rule of law is about. The US is in turmoil for many years, but it's even in more turmoil now. The basic international institutions are facing significant trouble. We are seeing that institutions like the United Nations are lacking financial resources to carry out their work. They are facing distrust and even hostility, even from the US, where they are actually based, situated, as far as their headquarters is concerned. And of course, in recent years, we have seen all across the globe very significant cases where either major superpowers or other important countries who belong even in the Western world have violated the principles of the UN Charter and international law. The fact that we have had continuously in recent years, even by the US, the decision to impose sanctions on judges of and the prosecutor of the International Court is a very significant in itself. When you have increased political interference that threatens judicial independence, and this is coupled with disinformation and polarization, this poses a great risk to the rule of law. And of course, it goes without saying that the EU also faces this problem. It's not only the US. The EU has not yet managed to find its footing on major political things. The main problem is that democracy, on which the rule of law is based, has in its modern form a history of only a few hundred years. Actually, it's more, if you want, globalization only took place in the 20th century. But in recent years, we have seen the influence of democracy worldwide, and accordingly, the influence of the rule of law worldwide decreasing. This is a very important concern because we cannot disassociate the progress of democracy and the rule of law from the international scene. It is logical that each one of us begins with their own country. They view the problems of their neighborhoods, their cities, as the major problems. If you have a problem with a prosecutor in Greece, this is for lawyers in Greece more urgent, more close to them than if there is a problem in Australia or in the US. But we are a globalized society more than ever before. So how the rule of law operates is influenced at a global level. And we cannot perceive progress in the rule of law as a legal question that is disassociated from the political and economic question. Economic barriers obviously prevent access to legal services and justice and lead to inequality and lack of effective judicial protection. And of course, we live in an era of unprecedented technological change and liberalization. We need to be as open-minded and innovative as possible in order to effectively address the challenges and opportunities that this development presents. Since our field deals with the provision of services, it cannot be fully replaced by technology, since it is not simple for technology to substitute the need of the lawyers and judges to show their individual good judgment. But in order to stay afloat and continue to thrive, our field obviously needs to adapt. We can aim for more jobs only if we innovate instead of automate. I engage in fields not previously thought possible and adjust our working and educational practices accordingly. However, we need to be cautious. The argument that the use of sustainable information communication technology and AI, artificial intelligence policies, could increase indeed citizens' access to justice and potentially revolutionize legal work is an important argument. And ever since the widespread use of internet ICT has significantly impacted the workings of lawyers and courts, with the adoption of electronic justice systems contributing to an effectiveness improvement of the judiciary and law firm combined. However, whereas it is correct that the utilization of the potential of ICT and AI can indeed lead to an organizational transformation framework that would allow traditional institutions to improve their overall efficiency, this cannot really occur only on the technical level. We sometimes consider that technical change implies that there would be social, cultural, and relational changes that come without thinking. This is not really the case. One of the objectives by using ICT and AI has been to address the existing information deficits by making institutions such as the justice system more transparent, accessible, and interactive with citizens. And indeed, it has been proven that efficiency can be improved, and we can have lawyers and citizens alike have access to more information than ever before, not only at the national, but also at the supranational and global level. However, AI can be used for activities that undermine access to justice and the rule of law. I was talking a couple of weeks ago with a colleague who is one of the foremost international experts in AI, and I jokingly asked him, should we be afraid that AI system might press a button and destroy the planet? And he laughed and said, I don't think this is possible. What is likely to happen is that the AI will convince a human to press the button that will destroy the planet. So I don't know if that makes you feel better, but anyway, the point is that AI has great potential for more efficiency and progress, but at the same time, it entails risk. The European Union has indeed taken a major regulatory initiative in the AI Act in order to regulate unethical and less dangerous AI. What is the problem? The problem is that first, while this is a good initiative, the AI technology is changing as we speak. So whereas in order to regulate, we take a few years, when we have actually reached the point where the regulation regarding technology, much less regarding artificial intelligence, is taking place, the technology has already gone to the next level than what we were expecting. The AI Act, actually, we started discussing it before OpenAI launched ChatGPT, and of course, we all know that in a single day, everything exploded. The second part, as I said, is that we live in a globalized society. The fact that the EU does something doesn't mean much at a global level, because you need the US to be doing something similar. You need Japan, you need China, you need other countries to follow suit. And of course, as I said, international cooperation right now is not at all at a good level. This means that, and we are already seeing it, if you have a client, they will say, okay, I might do some work at the EU where I will be more heavily regulated, but my mother company will be in Japan or in China or in Egypt or somewhere where the regulatory framework will allow me to do whatever I want. So without international collaboration, the idea that the EU often has that by regulating it can change perceptions, it can change the world, is not so realistic. The empirical assessment of the use of AI and ICT more generally is being carried out in recent years in a number of studies. It is rather uncontroversial to argue that by establishing technical infrastructure and AI capabilities, and by utilizing AI tools and mechanisms, including legal informatics, one could increase the efficiency of law-related work and accordingly assist in the fulfillment of the justice system role. However, comparative studies relying on both quantitative and qualitative data and methods have concluded that unreserved optimism about the potential of technology to transform in government and e-justice is not in itself a sufficient approach, and that a more critical approach is warranted. A very interesting example is the project Making All Voices Count that ran between June 2013 and November 2017. This is a program that generated research-based evidence on how technologies contribute to accountable governance change processes and practice-based learning on how to support innovation. The initial objective was to support the development and dissemination of innovative approaches to fostering accountable, responsive governance by using tools and platforms based on ICT. However, when the 4-year program was concluded, contrary to its initial hypothesis, it concluded that not all voices could properly be expressed via ICT, and that increased transparency and open data were not in themselves sufficient to generate either access or accountability. Systemic problems could not be addressed by ICT, much less solved by them, as the ICT could not overturn these social norms that underpin accountability gaps, the digital divide that was mentioned before, the capabilities needed to transform governance and justice are developed offline and in social and political processes rather by technology. Therefore, I have to be critical to any suggestion that we can solve the problem of justice by technology, instead by treating them as political questions. The above is of particular importance when discussing access to justice and the legal profession, where the systematic failure to express the voices of the marginalized or the socially less wealthy unavoidably influences the system's potential to uphold the rule of law. Uncritical attitudes towards AI might actually lead to a deepening digital divide and risk, compounding existing exclusion. They might expand the possibilities for surveillance, repression, and the manufacturing of consent, and narrow the frame of necessary debates about accountable governance. Whereas AI unavoidably transforms immediately the technical elements of justice, the social system is less inclined to be affected by the digital transformation. What is so important about law, about justice, is that it needs the exercise of good judgment, dealing with values that are often conflicting is inherent in our personal and professional lives. Our fields are not theoretical, they are highly practical in the sense that their primary aim is to solve complex problems in real life. Grant Gilmore famously wrote in 1977 that in heaven there will be no law and the lion will lie down with the lamb, whereas in hell there will be nothing but law and the process will be meticulously observed. This might be true. This might be a possibility, but right now we are neither in hell nor in heaven. Progress of societies leads to new questions, new perceptions, new debates. What was a given 50 or even 20 or 10 years ago is now often debatable. The evolution of societies does not indicate that we are worse off simply because the standards on which society is perceived have changed. We will always have a long way to go. This is unavoidable when we are dealing with society. When an issue is addressed legally and socially, new issues arise that also need to be addressed. Follow-up question. This is a never-ending battle, further incompeted due to the continuous evolution of technology and how this affects the lives and norms of our society. There is no unanimity regarding the big political, social, or other values, and this is a big reason why concretely evaluating the facts in any given case is so important, and why the proper application of law cannot be an automated exercise, but only the product of a holistic consideration. We can technically have artificial intelligence take decisions, but we cannot leave either law or justice to the hands of artificial intelligence. Because if we are to do so, there will simply not be a reason to have societies anymore. Thank you very much.
Thank you. Thank you so much, Professor Emilianides, for a very insightful address. I would describe it as a call upon all lawyers for self-reflection, a call to examine what we do as legal professionals, why we do it, how we can do it better, what is our position in society, what is our role, how is our role defined and redefined when using AI. But at the same time, outlining the issue of government accountability and the role of lawyers in safeguarding the rule of law when faced with such challenges also reminds us of the famous Napoleon quote that he would cut the tongue of any lawyer who uses it against the government. And I think that proves the historic continuity of what we fight for and what our struggle for the rule of law is for us as lawyers and the legal profession as a whole. So thank you very much. I think